So welcome everyone. I'm Catherine Wygant Fawcett, the Executive Director of the Institute for Family-Owned Business, otherwise known as IFOB. We have Brooke Stewart, our Director of Communications, joining us too. Thank you to PretiFlaherty for sponsoring us today. We've muted everyone and turned off your videos so we can focus on the presentation. We'll be recording this program for later viewing. We'll also share the slides after the program and some resources. And we want to make this as interactive as possible, so please send us your questions in the chat feature. As many of you know, the IFOB is a nonprofit that helps family businesses succeed. We're offering over 60 programs this year, both online, in person, and hybrid. So it's kind of fun today. We're like, okay, now we're back on Zoom. So we had been in person, so now we're back in Zoom world. So we work with CEOs, we work with women in family business, we work with the next generation, and we work with leaders in transition. So check out our website at FAMBusiness, that's fambusiness.org, to learn more or contact Brooke or me. We're both available here and on the chat. Today, thanks to PretiFlaherty, we have our third in our series of online programs called Legal Lunches, where we pair up the expertise of their lawyers with family-owned businesses. Working for the Weekend covers team safety, including wage and hour, OSHA, and workers' comp in a post-COVID world, although I'm not quite sure we're out of post-COVID, but we're working on it. And presenters are John Cronan, Associate, and Laura Rideout, Partner with PretiFlaherty. And we have Mike Davis, President and owner of Industrial Roofing Companies. Our next Legal Lunches is on Thursday, December 2nd from 12 to 1 on Zoom, called People Are People, the Most Challenging Employee Personas and How to Manage Them, presented by Laura, again, from PretiFlaherty, and Deb Whitworth, owner of CEO of HR Studio Group. I'm sure none of you have any difficult people that you work with. So our last program of the year will be on Wednesday, December 8th from 5 to 7 in person, and that's our holiday party. So that's at the Woodlands, and we like to call it mingling and jingling. So we hope you will join us for that. Towards the end of the program, we'll be putting a link to a survey in the chat. Please fill out the survey, as that is how we build our programs. And now I'll turn it over to Laura.
So we'll start off by introducing ourselves, and I'll go first. First, I want to thank IFOB for having me back for this third Legal Lunch presentation. I've really enjoyed the previous two, and I look forward to the presentation next month as well. For those of you who I haven't had an opportunity to meet in person, my name is Laura Rideout. As Catherine mentioned, I'm a partner at PretiFlaherty. I practice in the firm's labor and employment and litigation groups, and a large part of what I do is advise businesses about how to comply with the laws that impact their workforce. And so today during the presentation, I'll be touching upon some of those laws, and we'll talk about various scenarios that can come up related to the pandemic that can implicate compliance obligations with those laws.
I'll go next, I guess. Hi guys, my name is Mike Davis. I'm president of Industrial Roofing, located up here in Lewiston, Maine. We have an office in Massachusetts as well, primarily focused on commercial roofing services and solutions throughout that area. We've got about 100 employees, maybe 99 after this law. You know, very happy, been very involved with the IFOB, and very pleased to be part of a discussion about safety with all of our companies, and look forward to the discussion.
Thanks, Mike. My name is John Cronan. I'm an attorney with Preti. I just want to start off saying thank you, everyone. It looks like we have a very big audience today, and I look forward to this. And thank you, Catherine, for coordinating this. My main focus at Preti is defense of workers' comp claims. I defend claims for employers and insurers throughout the state of Maine, cases in litigation, also counseling employers and insurers on compliance with certain issues, and dealing with certain workers' comp issues and claims that come up. So that's the main focus of my practice, and I look forward to sharing some pointers and some advice, and taking some questions about that topic today.
So as Catherine alluded to earlier, I think there was some optimism when this presentation was initially conceptualized last year that at this point in November 2021, we would be sort of out of the COVID universe. We would be looking prospectively But unfortunately, I think as we've all realized that this is a situation that is going to continue to adapt and evolve. And so it's incumbent upon all of us to sort of stay apprised of how things are changing and how we need to adapt going forward, and that we probably are not going to be returning to what used to be, our normal situation, and we're really looking at our new normal. And so today, what we're really trying to do is cover 3 really huge topics that could independently take up a whole hour-long presentation. So we're sort of sensitive to that, and John, Mike, and I discussed how can we really effectively cover each of these 3 topics without bombarding you all with too much information in too short of a time period. So the happy medium that we're going to try to achieve is covering these topics on a high level, focusing on some key takeaways. But if there is anything that you are interested in drilling down further on, please feel free to submit a comment using the comment function. We'll also do our best to try to save some time at the end of the presentation to answer any questions that you might have. And I know John and I are both more than happy to discuss any questions that you might have after the presentation is over as well. And our contact information will be made available to you. So please reach out to us with any of those questions. And as Catherine mentioned, we'll also make these slides available. So again, we're a little heavy on content. Don't worry too much about taking down everything in the slides or absorbing every piece of content on every slide, because we will make sure you have that as a resource going forward. So as we've done with previous legal lunches, we really like to start with some poll questions to take the audience temperature on some factors that are going to be relevant to the discussion today. So Brooke is going to help me administer these polls. The first question we wanted to ask is, does your business have any employees that are working remotely? And we'll leave this poll question open for about 15-20 seconds.
Actually pre-launched it. It looks like people started to add it in now if you want to view those.
We'll leave it open for a few more seconds. Okay, Brooke, would you mind sharing those results?
There you go.
So it's not a surprise, but it's looking like most of you do have a portion of your workforce that is working remotely, which is obviously very common right now. Next question. Does your business have more than 100 employees? Okay. Let's see here. Brooke, I'm not seeing on my end that anyone's responded to this one yet.
Yeah, I don't either. I'm not sure what, everyone see it? It won't let you submit it. Okay. Let me try to relaunch it real quick. Question 2. I'm not sure why it's not allowing. So it's poll closed, relaunch poll 2. Okay, can you guys try now and see if it will work for you?
Perfect.
Sorry about that. Happened.
No worries, it happens. Okay, let's publish those results, Brooke. We have a pretty even split here where about 50-50 in terms of potential coverage for this new OSHA ETS that we'll talk about later on in this presentation. Okay, next question. Does your workplace have any type of a COVID-specific prevention and control plan? Okay, let's go ahead and publish this one. Looks like most of you do, which is great. Are there any workplace safety measures that are still happening in your workplace? So examples would be those plexiglass screens, if those are appropriate, or masking or social distancing. All right, let's publish these results. Again, most of you are still doing these things. So that's great. So we'll sort of take those answers and sort of weave those points into our presentation going forward. So the first topic we're going to talk about is what types of wage and hour issues are arising most frequently because of the pandemic. And fortunately, the US Department of Labor has given us some guidance on some of the most common scenarios that are creating confusion. So what I want to do today is walk through some of those common scenarios, and we'll hear from Mike a little bit about how his company is confronting some of those. So the first question that comes up quite frequently is, what happens if your business has slowed down? Maybe you can't support the same level of staffing that you once could. Are you able to adjust your employees' schedules or cut their hours in order to mitigate some of that? And the answer really depends on what type of an employee we're talking about. We want to look at how that person is classified. Are they not exempt from the minimum wage and overtime protections in the wage and hour laws? Or in other words, are they an hourly employee? If so, you don't need to pay those employees for any hours that they don't work. So it would be okay to take those employees off of the schedule without running afoul of any of these wage and hour laws. Although you might then run into some staff retention or workplace morale issues, which is a subject for another day. If you have exempt employees, so employees that you're paying a salary, you're probably not going to realize any financial benefit from sending them home a day a week or a couple of days a week, because the law tells us that we need to pay them their full salary for any week in which they performed any work. What
And
about if—
Laura, I just wanted to add on that point, if there are companies that have, really suffered in terms of revenue or even really supply chain issues related to COVID, if you haven't already done so, you should talk to your accountant about the employee retention tax credit. A little bit of an offshoot from the conversation today, but it could be a very impactful resource for you to explore. I just wanted to throw that out there.
Yeah, great point. Thanks, Mike. So what if your business has in place, we talked about some of these workplace safety measures that you might still be using in your workplace. What if you have some type of a health screening requirement? Maybe you're requiring employees to have their temperature taken before they enter the workplace in the morning, or some other type of screening procedure. We need to be making sure that we are paying employees for time spent submitting to those mandatory health screenings or health checks. And the same is going to apply to COVID testing. A lot of my clients have at this point adapted some type of a COVID-19 policy. Some are choosing to do vaccine mandates. Some really like the idea of allowing employees who do not want to become vaccinated to submit to weekly testing instead. And as we'll hear later, that's something that's addressed in the brand new OSHA emergency temporary standard. So the question is, do we have to pay employees for the time that they spend getting a COVID test? And the answer to that question is also yes, if that's something that they're going to be required to do as a condition to showing up in the workplace. What about if an employee has to quarantine because they've been exposed to COVID-19? This is something that's a little bit tricky. There used to be requirements related to this for certain employers to provide paid time off. There used to be tax credits available if employers chose to extend those benefits beyond what they were required to do. My understanding is that those tax credits are no longer available. So what the wage and hour division is telling us is that we should at this point as employers try to be as accommodating and flexible as possible for employees that are in this type of a situation. If we can continue to offer paid time off for employees who are quarantining, great. Can we introduce some sort of an alternative work arrangement where we are allowing them to telework for the period of their quarantine? Is there a way to utilize them in some way so we're not sending them home without pay? Mike, I know your company has a good approach to handling this.
Yeah, we've sort of had a few phases in this area. As it started and throughout kind of phase two, we were very flexible. We communicated it openly. We definitely didn't want people to come in that were exposed. And we also tried to outline opportunities for training at home so that even if it was a question mark, everyone knew they were going to be paid and they'd have, online training opportunities, and, we could all be better for it. Our latest phase, call it phase 3, is getting a little bit more strict in that we have not mandated a vaccine. We're encouraging it more individually, if you will. But we do have a new policy that says if you are vaccinated and you have to quarantine or you get sick, then there is some level of pay there. But if you're unvaccinated, then you could be not paid. So that's kind of the most strict current phase. And it's sort of an area to encourage vaccination, but not falling short of mandating it.
So another scenario that comes up a lot is we have employees who for the first time are teleworking, or maybe are teleworking or working remotely on a more regular basis than they used to. And so the key point to keep, you know, on the forefront here is that we want to make sure employees are recording their time accurately when they're not in the office. We want to make sure we're paying them for all of the hours they work, whether they're in the physical workplace or whether they're at home. So properly tracking time and making sure that employees are being paid at least the minimum wage for all hours that they're worked, and that they're receiving overtime pay for any hours over 40. What if you need to consider reducing salaries because you're having some financial hardship? Is that something that can be done without violating the wage and hour laws? The answer to this question is yes, in certain circumstances, but you have to be careful. These types of salary reductions can happen on a prospective basis. So going forward, if they are tied to either COVID-19 or an economic slowdown, and the person is still receiving that minimum salary level so that you're not jeopardizing their exempt status under the wage and hour laws. And so in Maine, that is at least $700.97 per week. What you cannot do is make salary adjustments to account for day-to-day fluctuations in the needs of the business. And salary reductions can't in any way be tied to quality of work that's performed or quantity of work that's performed. So many employers are also, you know, in order to encourage vaccination, offering various types of incentives to employees. And that might be a payment, that might be something else. Something else that sort of comes up in relation to this is making sure that if an employee receives an incentive payment and worked overtime in the week when the incentive payment was made, that we're including that payment in overtime rate calculations the same way that we would with bonuses or commissions or other types of compensation.
And Laura, I would just say from our experience, we did that. We gave a $100 payment as an incentive, and it did seem to move the needle and encourage some to do so. So that was a great investment on our part. And if a member hasn't tried that yet, I'd encourage it.
So the last wage and hour issue I wanted to discuss is, you know, are any of you allowing your employees to bring their kids to work? Obviously, daycare is a huge problem right now. I'm sure many of your industries are facing labor market shortages and staffing shortages. And I know from personal experience, having 2 kids, that the daycare industry is especially hard hit by this. And so employers might be trying to help out their employees by allowing them to bring their children to work with them. But I would caution against that approach. You know, there's obviously safety concerns at play if children are not receiving the type of supervision that's required. Workplaces might not be age appropriate, or might have other safety issues for having children there. But also, you know, as parents, I think we want to give our kids a task or a chore or a job to keep them busy and give us time to get something done. And we have to be really careful about if that's happening in connection with the employee's job, because we would potentially be triggering some child labor law issues if kids are helping out around the office when they're coming to work with their family. So just be careful about that. And that really concludes what I wanted to cover for sort of the main issues that come up with wage and hour related to the pandemic. So now we'll really transition into the heart of the presentation, which is workplace safety issues. And the first thing I want to talk about is very timely, and that is the brand new OSHA emergency temporary standard, which was published at the end of last week. So this OSHA is standard. It's a mandatory standard that is going to apply to all private employers that have more than 100 employees. And the standard has multiple components. The one we're most concerned about and we hear most about is this mandate or test requirement, where employers that are subject to this standard are going to have to require that their employees be fully vaccinated by a certain date, or alternatively, if they're not vaccinated, they're going to have to submit to at least weekly testing showing a negative COVID result before they can come into the workplace and wearing a face covering when they're in the workplace. There are various other requirements as well, including having a written policy, enforcing that policy, providing information to employees about the standard, providing paid time off for employees to receive the vaccine and to recover from any side effects, and also, other record keeping requirements and reporting requirements as well. So the most common question, understandably, is how do we know if we count as a private employer with 100 or more employees? For some of you, it might be a really straightforward analysis. I have more than 100 employees. For some, it might be somewhat confusing. So we do have some parameters that we take into consideration in order to figure that out. The first one is you might have multiple physical workplace locations in the state or in the country, and you might have less than 100 employees at each of those independent locations and wonder, okay, well, does this apply to me? The answer is going to be yes. If you have more than 100 collectively, you're going to fall under the purview of the standard. You're going to have to include full-time employees, part-time employees in that calculation. Don't need to include independent contractors, but be really careful about whether you're appropriately classifying an employee as an independent contractor. And I know that's something that John will talk about as well in connection with workers' comp. And then the other question I get is, okay, well, we have sort of one corporate umbrella, but we have multiple separate legal entities and they are all separate employers. So do we need to count all of the employees across the entire enterprise in order to figure out if we fall within this 100 employees or not? And this is kind of a tricky question. The guidance we have from the standard is that if the entire organization is handling safety matters as one company, for example, one set of safety policies and procedures, one written policy, one person who handles these issues, then that's going to indicate that, yes, we need to be treating these separate, distinct entities as one for purposes of this standard. And then we also have some suspicion that some of the traditional principles that apply when we look at this question in relation to other employment statutes, various employment statutes kick in if employers have over a certain number of employees. And we look at principles like the joint employer doctrine and the integrated enterprise doctrine to see if we should be treating separate companies as one under those laws. So really, we're looking at how interrelated is the ownership of those companies, or how interrelated is the operation. And we have reason to believe that some of that analysis might actually come into play also with this OSHA standard. There are some exceptions. If we have employees who will never enter the physical workplace or will never come into contact with a customer or a coworker, then we don't need to require them to comply with the vaccinate or test requirements. If we have employees who work exclusively outdoors and will never set foot inside an inside workplace, they might potentially be excluded. And of course, if we have employees who need some type of a medical or religious accommodation, because they cannot either become vaccinated or submit to the weekly testing, then we need to evaluate whether it's necessary and appropriate to have an accommodation for those individuals. There's a lot of information about how to handle the testing component of this standard. I won't go into detail on this for the sake of time, but I have included some of the key points in this slide for you to review at your leisure. Suffice it to say, there is some flexibility built in about how to administer that component of the standard. What about the compliance deadline? So this is kind of an interesting question. Based on the language in the standard, we know that there's sort of a two-tier compliance deadline structure. December 5th is a compliance deadline for everything in the standard except for the vaccinate or test part. And that part kicks in on January 4th of 2022. But as you may have heard, 26 states across the country have submitted legal challenges to this emergency temporary standard on various grounds. And this is being heard in different circuit courts across the country. And so we don't really know, what the outcome will be for this standard after these suits are resolved. We sort of have to stay tuned and track that information. But there really isn't a lot of time to sit and do nothing in that interim period. So my recommendation would be to lay the foundation for compliance if your organization is covered by this standard, and then stay tuned to see how the standard fares as these legal challenges are resolved. I also wanted to point out that there are penalty provisions built into the standard for non-compliance, and those can really add up based on the way violations are defined. So this slide gives you some high-level points about what types of things you can be doing now to prepare for those two compliance deadlines if your business is going to be subject to the emergency temporary standard. Now, what happens if your business is not subject to this new standard or one of the other standards that applies, for example, to healthcare industry workers, or to federal contractors? There are various vaccine mandates that apply. If you don't have to follow any of those, what do you need to be doing? It's important to keep in mind that OSHA has published guidance for employers that don't fall into any of those categories and recommends certain safety measures be taken to protect employees from exposure to COVID-19 in the workplace. And the way that OSHA regulates that is through the general duty clause, which requires employers to basically provide a safe and healthy work environment that is free from recognized hazards. And as we all know, COVID-19 is a recognized hazard. So OSHA recommends what they call multi-layered interventions in order to protect against exposure in the workplace, and containment if there is, exposure in the workplace. And I've summarized some of those multi-layered interventions for you here. Remember that this is not a one size fits all. It's a very case-by-case basis type of analysis to figure out what interventions are appropriate in the workplace. You need to evaluate what the risk is, who are the people who are most at risk or most vulnerable, and then tailor your safety measures to address those concerns. And another question I get all the time is, okay, well, do we really have to do those things? How are they going to find out if we don't do them? Which is a fair question. And the way it's probably most likely going to come up is if there were to be an outbreak in your workplace, and then you're going to have OSHA inspectors looking into whether you're doing any of these things and trying to figure out, well, why did this outbreak happen? Is this something that could have been prevented? And OSHA has been very active in issuing penalties for violations of the general duty clause because of COVID-19. And as you can see here from the screenshot I took from OSHA's website, they've assessed penalties of over $4 million as of the end of October. So this is certainly something that's on the radar screen of the regulator. And with that, I will pass the torch over to John to pick up with workers' comp.
Thank you, Laura. Appreciate it.
Can I pop in for one quick second? We had a couple questions, Laura, that came up.
Sure.
So I thought it might be great to ask those. So is there any distinction between those that quarantine who are vaccinated and those who are not vaccinated?
That's a good question. I would want to go back to the CDC, the latest CDC guidance on quarantine standards before I answered that definitively. I just haven't looked at that in a while. And I know
I know Mike talked about, he made a distinction, but I'm not sure.
Yeah.
That's what we follow CDC guidelines, which actually, if you're vaccinated and exposed, then you don't necessarily need to quarantine. So every case is different, and we've kind of handled internal champions to talk with the affected employee make sure we fully understand the situation, and then kind of go down that road or take that fork in the road, so to speak.
Yep,
Okay,
that's
this-
my recollection as well, Mike. And what I can do, Catherine, is when we follow up with some links to guidance, I can also link to the latest CDC guidance on quarantine
Okay.
standards.
Great. And then there was one more question. She says, I think the big question that all of us are wondering about is who pays for the testing?
That's a really good question.
There you go.
So we talked about who pays for the time spent submitting to the test, and that's something that the employer should probably be paying for if that's something the employer is requiring. The emergency temporary standard actually tells us that the employer does not have to pay for the test itself. And this is kind of a tricky question, you know, just because the employer doesn't have to do something, does that mean it shouldn't do something? You know, there's some room for interpretation there. And I think, you know, based on my own observations with my own clients and, you know, speaking with so many employers, there's obviously a lot of workplace morale challenges right now. It's really important and a priority to try to retain our staff and value them. And so, you know, I wonder if requiring our employees who are maybe not happy about vaccine mandates, tired of COVID-19, fatigued by all of this, like we all are, you know, requiring them to fork out $20 for an over-the-counter test every week. You know, is that something we want to pass the burden on to the employee or not? I think we could have a lot of discussion about that. And I'm sure there are a lot of considerations both ways that would weigh into that. But based on the language in the emergency temporary standard, employers are not required to pay for that. And I know that that factors into the analysis about whether an employer wants to mandate the vaccine or wants to allow employees to have that testing alternative. That's a choice to make. And some employers are saying it is too burdensome for us to administer weekly testing. We don't want to do that. So we're going to have vaccination, or then that's it. Vaccinate, or you can have an accommodation if you need it. So there's room for flexibility and decision making there, but certainly there's a lot of factors that go into what the best choice is for your workplace.
Okay, and then we have one more question. If you are possibly exposed, aren't the tests free?
Yeah, so that's potentially true. I personally haven't had to get a COVID test. I've never been exposed. So I know, I think you have to show proof of insurance. There could be something there. And in terms of getting an over-the-counter test, if you're not in that type of a scenario where you've been exposed, I think there could be different requirements.
Okay, thanks. That seems to be all the questions now. I'll pop on if we get some more after John speaks.
Great, thank you.
Great. Thank you, Laura. Appreciate it. Well, we're going to talk a little bit about workers' comp in a post-COVID world here. Workers' comp is here to stay. It just, things look a little different these days. And we'll go to the first slide if we could, in terms of what's compensable under the Workers' Comp Act is the first question. This has been for decades and decades. The Workers' Comp Act in Maine has basically said that an injury that arises out of and in the course of employment is likely or is going to be compensable under the Maine Workers' Comp Act. We know what this looks like in a lot of cases when the injury happens in the four walls of the employer at a place of work. But it looks a little different when the employees, or as most of you pointed out, 71%, I believe, working remote, when an employee is not in the physical office. So the key questions to ask is, you know, when did the injury happen? Where did it happen? And what was the employee doing at the time of the injury? And one of the things we've looked at lately is whether COVID is compensable. And we've been at this for over a year and a half. And really contracting COVID-19 in the workplace is still a legitimate question that really is, there's a lot of facts that go into the analysis. And there's a lot of factors to look at in terms of what was the employee's job? What are the sources of exposure? You know, there's a whole list of things that the insurance companies and the clients I work with often look to the employers for to provide information in terms of what is potentially at issue here that could make this claim compensable. And the bottom line is, you know, contracting COVID-19 may cause an employee to make a claim under the Workers' Comp Act. And the test is really whether the risk the employee faces in the workplace is greater than the general public in terms of contracting COVID. A lot of businesses don't deal with the typical situation where we have healthcare workers, frontline EMS, EMT, police officers, that kind of stuff. Those things in some cases can be a higher risk for contracting COVID. It's less likely, and it's more likely in some cases that you're looking at a risk that's equal to someone in the general population when you're in a traditional workplace environment. So we can go on to the next slide at this point, just to see what's there. So we have some guidance from the Workers' Comp Board, and the main Workers' Comp Board has outlined some issues that come up. And the first one is if an employee was exposed to COVID-19 while at work, or even if they think they were exposed to COVID, should I tell my insurer? And the question is absolutely yes. And this ties into one of the points below here, is that a first report of injury is something that the employer is directly involved with the insurer. And even if an employee claims they got COVID at work, that it may be caused by work, if there's any hint of it, a first report of injury should be filed with the Workers' Comp Board. And that's even if the employer or the insurer don't think that the injury is compensable. It's not an admission that the injury is compensable. You're not buying the injury. You're not claiming, you're not, signing up to pay any benefits. You're simply reporting it as you're supposed to under the Workers' Comp Act. And that goes for contracting COVID and also any adverse reactions to COVID, which I'll talk about in a second, which is a big thing because there's this vaccine mandate. And there's also employers that choose to mandate vaccines and some that don't. And the other point I want to address is, if we could just go back one sec, can healthcare providers submit bills for telehealth services? This is somewhat unrelated, but it is something that certainly can happen and does happen. It's more relevant to the insurers usually than the employers, but it is out there. And it's something we see a lot more in workers' comp these days. Although the doctor's offices have opened back up, continue to open up, we're still seeing a lot of telehealth services. We can go on to the next slide, please.
John, if I could just jump in there.
Sure.
I would just add to the people on the call, if you haven't gone through this yet, to sort of start a hypothetical of, what if we got one of these claims, what would our process be? And we did that before it ever happened. And we also talked with our insurance company, understood what their process was going to be. And so we had a very good understanding of what to do. I think we only had to go through it one time, but it was good to have an understanding ahead of time of what it would look like. And then in our case, our insurance company has, a third-party administrator that basically set up a full process for surveying the affected employees, contract tracing, all of those things. And it was a very detailed, process / investigation that, allowed us to be, kind of consistent and handle it appropriately. So if you haven't already done so, kind of understand what it would look like and be prepared.
Right. Thanks, Mike. And that's a very good point. This is one of the times, and a lot of times in workers' comp cases, but this is one of the key ones where the employer will play a huge role because the employer is the source, is really the key, has the key information here that the insurer will need to know about. And there's not a lot of time in workers' comp cases. If there's a claim to medical bills and lost time, you really got only 14 days when someone makes a claim to lost time, if they are losing time from a COVID issue, to deny the claim or to start paying the claim if there's wage loss. So, that in that case, the investigation is very important. And you want to look at what, as Mike said, what the employee does for their job duties. Have they traveled? Do they have a legitimate or an actual COVID diagnosis? In some cases you need to, it's not clear whether there's even an actual diagnosis by a medical professional. And that's something that's absolutely key. The other thing is, what do they do outside of work? All those things are very important to look at. And it's really, really fact specific, but there are certain ways to evaluate it. And in terms of vaccines are really, there aren't a lot of cases, a lot of hands-on law in terms of vaccine reactions, but there is some word from the Maine Workers' Comp Appellate Division in terms of an adverse vaccine reaction. We can go on to the next slide, please. So there was a case a few years ago from the Workers' Comp Appellate Division that didn't deal with COVID long before the pandemic, and it dealt with a hepatitis B vaccine that an employer encouraged but didn't require. And there was about one shot with 2 boosters. The employee underwent 1 or 2 of the shots with 1 booster, developed a very bad reaction, claimed it was work-related, went all the way to the Workers' Comp Board Appellate Division, and the injury was found, the reaction from the vaccine was found to be compensable, and the employer and insurer were ordered to pay and were found liable for the vaccine reaction. And this is even when the employer doesn't have an official vaccine mandate. In that case, it was only encouraged and it benefited the employer to have this employee work for them. So the question becomes, if an employer in Maine has a vaccine mandate on their own, it's very likely that a vaccination reaction would be compensable under the Workers' Comp Act. Even if they don't, it's still leaning towards compensable in many cases because it generally could be found to benefit the employer. And it really depends on the facts of the case. Now, the question becomes, what is the effect of this, and what Laura touched upon, the OSHA 100 plus employee rule dealing with test or get vaccinated. If an employer is subject to that and an employee is vaccinated and has a reaction, the question becomes whether their employee would really have a strong claim to compensability if the employer took a neutral stance on the vaccine. And there's a good argument to be made that because the federal government the government is imposing a vaccine mandate, it's really not the employer that's encouraging this, although the employer still benefits from it. Stronger argument could be made that it's not compensable. But there's certainly cases out there that show that this is a real thing and something to be aware of. And we can go on to the next one. So the other key thing is, contracting COVID in the workplace is one thing, but bottom line is the more practical thing we're dealing with is with 71% of you with remote workers based on what we've seen in the survey. What is a remote work injury? Is it work related? And it's the same test that we talked about before, arising out of and in the course of employment. And the key is to realize that our work injuries that people sustain outside of the four walls of the office compensable? They absolutely can be. The Maine Supreme Court weighed in a few years ago in a case involving a guy who worked for the Salvation Army. He worked at home. His employer condoned it. He was allowed to have his office and setup was authorized by the employer. And he had a heart attack while he was on a treadmill. And he was unfortunately, he was found dead next to the treadmill with his BlackBerry or smartphone with the financial news on. The allegation was that stress from work caused him to have a heart attack. And even though he was on a treadmill, he was still stressed from work and he was near his home office. And their injury was found compensable after a long, hard fight all the way to the Maine Supreme Court. And the significance of that case is that it's not really about stress and heart attacks necessarily. It's that injuries can be compensable even if they're not in the office. And so you really need to look at certain factors. The main courts and the Workers' Comp Board looks at things like, did the incident occur during working hours? Where did the injury happen? Was the employee engaged in work at the time of the incident? Was the task, for example, something for personal comfort? Even getting a bottle of water or a cup of coffee, even deviating a little bit from work is not going to make it something that would ordinarily be a compensable injury not compensable, unless there's really some big deviation. And it's a very fact-specific test, but the bottom line is if the injury occurred when the employee was doing something that benefited the employer and really wasn't prohibited by the employer at all, and was authorized by the employer, which oftentimes work from home employees are in this day and age, then you're dealing with a strong case for a compensable injury. And that's something to be aware of. Ready for the next slide, please. The other thing we're dealing with in this day and age is the issue of independent contractors versus employees. And I won't get too much into the weeds with this because this is a very dense topic. The bottom line is there's always this tension in workers' comp cases and in certain businesses, certain industries, whether this person is an independent contractor, is an employee. There's tests under the Workers' Comp Act. There's multiple factors that show if you meet all these factors and X amount of Y factors, the person's an independent contractor or the person's an employee if not. This is all the more important in this day and age with remote work, when you have people that either A, aren't coming into the workplace, or B, they're exercising some more control at home, or there's just a different relationship than the typical clock in, come in, work in the workplace that could make employers either mistakenly think that someone is an independent contractor, or vice versa, make the employee or the individual think that they're an independent contractor. Because an independent contractor isn't required to have workers' comp insurance. But the problem is that an employer and an employee can't just agree on their own terms that, oh, this person's an independent contractor, or this person's not. And even a written contract between an employer and an employee isn't going to cut it. The board offers an option, the workers' comp board offers an option for a predetermination of independent contractor status. And if someone is working remotely, and this comes up a lot more, like I said, in remote situations where the lines are a little fuzzier, a little more blurry in some cases, you can ask the board to tell you whether this person is an independent contractor or not. And although it still can be overturned down the road if you get in a legal litigation before the workers' comp board about it, it still obviously carries some weight. And the problem with that is that this worker misclassification is a huge thing because there can be tax penalties and labor law, safety violations, unemployment premium issues, things well outside of the sphere of workers' comp. And there's also the issue of potential lawsuit if an employee is injured on the job and there's a misclassification issue. So those are big things to keep in mind when dealing with this distinction. And we're ready for the next one, please. So return to work safety is another big topic. This is something that's really important because we've seen and we're bound to continue to see an increase in workers' comp claims when people return to work after a long time off from work. Unfamiliarity, just basic unfamiliarity with the workplace in some cases, new surroundings, different surroundings. And one of the big things is employees that started at a business or a workplace during the pandemic, perhaps sometime in mid 2020 or early 2020, and they're just coming back to the workplace for the first time in late 2021 or mid 2021. That's an unfamiliar environment that's it's ripe for any sort of problems in terms of safety issues and injuries because it's just simply unfamiliar new environment. So that's a key thing to recognize, that safety training programs and practices are key for longstanding employees that might be coming back, and also definitely for new employees to get them up to speed on these issues. One more thing I want to touch on for return to work survey, if I could, is the, and I won't get too much into the weeds with this, but there's a section, the Workers' Comp Act allows an employee to request to be reinstated to their job after an injury. And there's actually for 2 years after the injury, they have a right to reinstatement, or 3 years if they're over 200 employees. The bottom line is this is always something that's in play when someone is out on a work injury, and it's key for employers. Insurers obviously always play a big role in this, but employers particularly, because they're the ones that it falls on to look at and see what we can do to accommodate this particular person if they want to come back. And that can be a problem in some cases because the employer has a burden to show that it can't make a reasonable accommodation, or that it doesn't have jobs available to this particular injured worker. And so particularly when you're dealing with remote work situations, staffing adjustments with the pandemic, and the bottom line is in a lot of situations, you're seeing light duty jobs that employees that are injured would often go back to. They just don't exist anymore, or they're eliminated because things have changed around in the workplace during the pandemic. So that puts employers in a little more difficult situation. They need to look at and evaluate, when you're dealing with workers that are out on workers' comp, really regardless of why they're out and what the injury is. So that's another thing to keep in mind.
And I'll just attest here, John, that if you don't have a return to work program, regardless of COVID, just overall in your safety program, I think it's something that you should absolutely explore. For our company, it's been a huge impact. We haven't had a lost time injury in over 6 years, and our safety culture is quite strong, something we're very proud of. And a key part of that is a very progressive return to work program. And I mentioned it earlier, having ample training opportunities, online training opportunities. So if someone is affected or injured, they have those opportunities. They can still earn wages and then, become better, stronger, more trained employee when they get back to full speed.
Thanks, Mike. Very good advice. And before I don't, Laura might have something to say. I do notice the time. We only have a few minutes left, so I do want to leave enough time for questions. So I'll turn it over to Laura to perhaps open the floor back up.
Catherine, I'll ask you, I can't see based on the layout of my screen whether we have any comments or questions. Oh, I think you're on mute, Catherine.
You're right. You think we would all know this by now, right? I just put that out for the chat. If anybody has any other questions, I haven't seen any new ones come through.
Like we said, we will make sure that the slides are available. We'll put together some links to some of the guidance materials that we drew upon today for our talking points and our remarks that might be useful to you if there are those little nuanced questions that you want to drill down in more detail on. And of course, feel free to shoot us an email. We're happy to share what we know or where we know to find the answer if we don't know.
Thanks, Laura. I was going to say that I'll echo what Laura said. If there's any specific questions on what either of us talked about, don't hesitate to shoot us an email or give us a call, and we'll be happy to talk about it.
So I have a question for Mike. What have you found as the best way to kind of navigate these challenges going on? What kind of resources and things do you pull from to help?
Well, we overall, we've been very fortunate. We set up a COVID task force here as a company. And so we've got kind of a diverse group of 5 or 6 people that, all research and talk to different resources and create that web of knowledge. And we try to be as proactive as possible. Definitely follow CDC guidelines at least, and try to maybe even surpass those. Communicate as regularly as you can. I was sending out video text messages to our entire crews pretty regularly. And the last one is not necessarily to overthink things. We just don't know what the future is going to hold. And we started by kind of trying to predict every scenario. And we then just realized, look, guys, we don't know what it's going to be. So let's just take this in phases. Here's where we are right now. You set up the plan, everything's subject to change. But that also helped just really calm down the situation. We did it in phases. We knew, and now we're into a new phase. This is kind of like phase 5 right now. But you never know what it's going to look like in a couple months. You don't know if these appeals are going to hold. So you basically got to set up a process of what you know. And then as it changes, you just revisit it. And that's kind of the overall approach that we've taken.
And you're also working in a couple different states, and you have remote workers and people going on site too. So that's probably added a couple layers of complexity.
Yeah, pretty dynamic.
Yeah. So I wanted to thank you all so much for attending today. As we said, we've put the survey link in the chat, so please take a moment to let us know what you think. We'll keep this session up for you for a few minutes. Thank you to our sponsors, PretiFlaherty and Main Biz, and thank you to Laura, John, and Mike, our fabulous speakers. You can join us on Thursday, December 2nd from 12 noon to 1 for another legal lunches with People are People, the most challenging employee personas and how to manage them. And just thank you all so much for coming. And again, our holiday party is on December 8th if you want to come on out and see people in person. So thank you, everyone.
Thank you.
Great. Thank you very much.